docket number 218-2022 CV 676. All right, Mr. Richard, have you had a chance to discuss things with your?
Yes, Your Honor. What I want to point out to you that I didn't emphasize earlier is that the state alluded to explosions. I want to get away from explosions, obviously, and get to the point of what the real safety issue is here, which is anyone that possesses a prosthetic, pacemaker, or other devices is possibly at risk here. And so this is a public health, public safety issue to allow these devices to continue to be used until we resolve these underlying issues. So with having said that, I'm going to object to denying just to put it on the record, that I object to not allowing my expert witness to testify because safety is always paramount. And that's what this is all about. I'm simply asking this court, and the reason I asked for this hearing was for a simple thing. There is no harm to come to Ken County this battle to make sure that we preserve the integrity of this vote. Right now,
When you say this vote, you mean the one next Tuesday?
the one next Tuesday, because as the state alluded to, I didn't do this at the last minute. I've been trying since at least February
Well,
to address the
let's
problem.
talk about that, because that's one of the things that's kind of bugging me, is that I'm all for doing things for public safety. I just tried to get everybody to wear masks. But the other issue is, if there's an exigency, but the delay in your filing the lawsuit kind of causes that. I mean, I think if we had argued about this in June, which I don't see a reason why we couldn't have.
I personally didn't possess any knowledge of the safety factors.
Okay,
until
explain that
just
to
a
me.
few weeks ago.
Explain why you filed the lawsuit when you did in so close proximity to the election.
Absolutely.
Some people do that for tactical advantage.
Absolutely, Your Honor. My journey with this challenge of changes to our voting laws starts with a first remonstrance filed 2 years ago with the legislature changing by statute that which requires an amendment. So that's the basis of the rest of the suit. So counts 4, 5, and 6 in the suit all deal with older issues that I've been trying to resolve through the administrative remedy, through working with my legislative body, including filing a petition with the state Supreme Court, which was argued over the right to redress a grievance. The underlying issue of the remonstrance there was items 4, 5, and 6 in this case. And so, having said that, after unresolving that issue through the redress process through the legislature and exhausting that remedy through the court, that was the court of proper jurisdiction, right? The state constitution provides that only the legislature is authorized to suspend the law or to change provisions within, changes to their legislative actions that are repugnant contrary to the Constitution. And so, having exhausted all that, I recently, in the last month, finally got my motion to reconsider from the ruling from the state Supreme Court. I then moved, so that's 2 years old. So that begins back 2 years ago. In February of this year, when I came to the awareness of machines and the problems and the possible legality issues, that's where I started my investigation on adding the machines to my concerns about how our voting is conducted. So having done that is, I then came to the awareness of the expert witness. I didn't know him until just a few months ago. Someone introduced me to him, and then I found out what his background was. A few weeks ago, I asked him to look at this from his perspective and his background. So that's why this is new information. And it was not done to the last minute. I would point to the state, that the state did nothing since February, other than the Attorney General's office issued, I'm sorry, it wasn't the AG's office, it was the Secretary of State's office. When we gave the remonstrance to the legislature, to the Secretary of State, to all the players involved, and then I served my town. And after the town got a copy, not only did they get a copy of the remonstrance filed with the legislature, but they also got a copy of the notice of trespass, because I believe they were trespassing on my constitutional rights. Part 2, Article 32, says that 3 elected human beings are responsible for sorting and counting the vote. The moderator is elected to sort and count the vote from the selectman or the town or city clerk. That has never changed since 1783. There is no amendment. And under Worcester versus Plymouth, the state constitution must be interpreted the way it was written on October 31st, 1783. There was no technology, there was no electricity. Counting by hand, and what we refer to today is voter integrity. What do we do when we challenge the outcome of the election? We hand count. Why is hand counting a de facto? Why are we ignoring the hand count and using a device that isn't even law? Statute 656:40 isn't law. Let me explain. 656:40 is the origins of the voting machine, okay? It came to us in 1979 on a trial basis. Your Honor, 43 years cannot be a trial basis. That's what they're hanging their hat on. That's where their legal justification for using these devices begins with. It begins with this temporary use authorization, and here's the kicker. We're not a home rule state. The legislature can't delegate to the town under non-delegation doctrine and give the town the ability to make law. It can't make law, the legislature makes law. So what does the statute say? It says that it applies to the ballot law commission. Who's the ballot law commission? An unelected body. An unelected body who then, you ask this unelected body as to whether you're going to ignore the provisions of the Constitution. So that's kind of the backstory of what's going on with the various changes to how we got here today. So yeah, this is not something new. I didn't wait till the last minute. The only reason this emergency hearing was brought forward was because of my serious concerns about safety. Thank you.
Thank you, Your Honor. The primary election is imminent, and granting the plaintiff's preliminary injunction would threaten the orderly administration of that election, which is only days away. The plaintiff has made clear that he wants to prohibit the use of ballot counting devices across the state, and has pursued a number of different avenues to do so. To require hand counting of every ballot by the moderators he has indicated. He additionally claims that ballot counting devices, which have been in use for decades, pose a safety risk. That's based on speculation. That's based on a misreading and misapplication of standards that he cites in their application to particular devices, and it's not based in evidence or any occurrence of injury or risk from the operation of ballot counting devices. Plaintiff's claims are unfounded and they're speculative, can't meet the burden that he bears for granting of a preliminary injunction. And I think the testimony today supports the proposition that ballot counting devices have been in use regularly in every election for decades in New Hampshire. They have done so consistent with the Constitution. They have been in operation consistent with New Hampshire law. They are consistent with certification by the Ballot Law Commission. All of that indicates that the preliminary injunction should not be granted in this case, would be improper to do so. Just like to touch on the operation of ballot counting devices. I indicate they've been in use for decades. My understanding is that from the mid-90s, that is when the AccuVote ballot counting device, which is the model that is approved by the Ballot Law Commission, has been utilized. They're used in approximately 200 polling locations across the state and handle roughly 3/4 of all ballots cast in the state. I believe that in the 2020 primary, that there were 147,000 votes cast in Republican primaries and approximately 155,000 votes cast in the Democratic primaries. That's more than 300,000 votes that were cast in the 2020 primary election. We're talking about a very large number of votes, and the majority of which are counted by ballot counting devices. As the plaintiff alluded to, adoption and use of ballot counting devices is proper, based on RSA 656:40. The approval by the Ballot Law Commission is under 656:41, and then consistent with 656:42 are the testing procedures and protocols that verify the outcomes and the voting, the ability highlighting there that the certification applies to the class of ballot counting devices in the state, the active vote machines, one type of machine. Every one of those machines is certified by that determination of the ballot law commission. Additionally, before each and every election officials in every town and city, town and ward, must conduct a test of that machine, of any machine that they intend to use in that election. That means breaking the seals on the machine in both the container and relating to the memory card, and then testing that machine against a series of test ballots that are hand counted to determine and confirm that the ballot counting device accurately counts those test ballots. That is an outcome-based test that assesses the ability of that machine in that particular election at that time to operate in that election. If the ballot counting device does not accurately count those machines and is not put into use in that election. And that's all consistent with New Hampshire law and the testing protocols established for the handling of these ballot counting devices that have been used for decades. I'd also point out to the court that there's an additional verification of outcomes in the use of machines that relates to the recount procedures committed under law as well. There's some testimony as to recounts doing them in one circumstance, but recounts routinely confirm that ballot counting devices accurately identify election winners. That is something that is very clear from the record of recounts in the state of New Hampshire. I'd also just like to touch on the history as presented by the plaintiff here, and identifying that he filed a remonstrance or remonstrances that had no legal effect, that he petitioned the Supreme Court, that petition was denied, that there have been ballot measures introduced in a number of towns across the state relating to the use of ballot counting devices as an exercise under the law of determining whether would utilize a ballot counting device or would hand count, where the people of the town vote on how they want their votes counted. Not a single one of those ballot measures passed in this past town election season in Rockingham. The plaintiff is seeking different venues for his ultimate goal of trying to prohibit the use of ballot counting devices. Today we're hearing a focus on the safety of ballot counting devices that again goes to speculation, that goes to possibilities that have not been realized in the history of using ballot counting devices in New Hampshire in every election. Moving to some of the legal questions before you and what is required for granting a preliminary injunction. New Hampshire case law makes clear that a preliminary injunction is an extraordinary remedy, and that it should be issued as only a preliminary measure to preserve the status quo. Prohibiting the use of ballot counting devices is not preserving the status quo. That would be a severe disruption of the status quo as the plaintiff seeks to do. And it is the plaintiff's burden to establish the granting of the preliminary injunction. The plaintiff must show that he's likely to succeed on the merits, that there is the immediate danger and irreparable harm if a preliminary injunction is not granted, and that there's no adequate remedy at all. Additionally, I would note that in this case, the plaintiff is seeking essentially, functionally, an outcome on the merits, a final outcome on the merits, of the use of ballot counting devices in New Hampshire elections. He is seeking that as part of a preliminary injunction. That raises the standard of analysis, because he is seeking a final outcome, a final win, in the form of a preliminary injunction filed days before this hearing, with expert testimony presented to this, court only a couple of days before this hearing. That's an improper use of a preliminary injunction. Putting aside decide that he does not meet the legal standard required to succeed on preliminary injunction. On the likelihood of succeeding on merits, the plaintiff cites the Constitution. He cited to Part 2, Article 32 in relation to his argument about the moderator conducting the counting of votes. Your Honor, he misstates the constitutional language. The plain language of the Constitution does not require hand counting. It does not require that one individual count votes, or even three individuals, as Leckie identifies, count the votes in an election. He misstates in his request for a preliminary injunction the status of an election. It is a public meeting. It is conducted in the open. It is conducted in public and must be. That's one of the reasons why counting has to occur on election day, is because the votes are collected, the votes are cast, the votes are counted, be it by hand counting or by a ballot counting device on election day. His interpretation and using his description of it, of saying either three people or one people can count votes, would render impractical any election in New Hampshire. To have one individual count the votes in a jurisdiction as large as our largest town, some 10, 15, 16,000 votes, that's not possible. The remedy is seeking presentation under a veneer of constitutional interpretation is not practical, and it's not consistent with longstanding practice, historical practice in elections in New Hampshire. There is no prohibition, constitution or statute, on the use of ballot counting devices. In fact, they are authorized under New Hampshire law. Jurisdictions use ballot counting devices on the basis of that authorization and have done for decades. The plaintiff also cites to a number of analytical sources of propositions that ballot counting devices are unsafe. Just note there that a number of the safety standards that he identifies for electric equalization systems, such as those installations that power lights for employee workspaces, maintenance requirements related to other public lighting systems or workplace lighting systems, electrical systems. Those don't apply. He cites a number of non-binding, voluntary, against that number of them are non-binding and voluntary, and insists that they apply and would preclude the use of ballot counting devices in New Hampshire. That's a misstatement of the legal obligations relating to the use of ballot counting devices, and it is contrary to the evidence regarding the safety of ballot counting devices and the ability to identify any circumstance where a ballot counting device posed a risk. I'd also just briefly touch on standing, Your Honor. It's slightly unclear that the text or descriptions that the plaintiff uses make it unclear as to whether he's referring to the ultimate objective of prohibiting the use of ballot counting devices across the state, whether the preliminary injunction would apply across the state, or whether he's just referring to Auburn. So to that end, Your Honor, we would assert that he does not have standing to contest the use of ballot counting devices across the state. That would be, if he does have standing, limited to Auburn alone. With this note that his request relating to the preliminary injunction does vary. It's not clear whether he is requesting a prohibition statewide or merely in Auburn, since it varies depending on the paragraph. He's also made no showing as to irreparable harm in the absence of a preliminary injunction. Again, that would be a threshold that the plaintiff must establish in order for the granting of the preliminary injunction to be proper. These ballot counting devices have been used for decades, dozens, hundreds of elections. They've been used routinely according to New Hampshire law, and there is no prohibition on the counting of the plaintiff's votes, as he asserts. He has at least three options for how the ballot can be counted. It can be through passing biases right to vote and cast a ballot. It appears from his prior action that he chose not to do that in the past, and could choose not to do that again, but that opportunity is presented to him both under New Hampshire law and election practice. Your Honor, just touching on this, since the plaintiff is insisting that this is about safety and public safety, he cites that applicable authorities relating to that can identify any particular risk posed by ballot counting devices. It's speculative. The evidence that he presented would refer to the modems, the wires, and modems and serial ports in the back of a ballot counting device being disabled or cut pursuant to an order by the Ballot Law Commission in 2010. The devices have been operating in that state since the issuance of that order. That's identified safety occurrences related to the disabling of those modems or serial ports. I'd also bring your attention back to the testimony of Mr. Eyring. My final question to him was whether in the course of doing an audit, when those ballot counting devices from him were being handled extensively, used, analyzed, pieces of them taken apart to be assessed, that at no point did any of those devices explode. And he called it a ridiculous question. Your Honor, that's because he understands the premise here and the evidence that there is no evidence supporting a safety risk for the ballot counting devices that have been routinely used in elections across New Hampshire for decades. It is that proposition and claim is ridiculous. Your Honor, I finally turn to the principle of judicial non-intervention as essential in this circumstance. It's commonly referred to as the Purcell principle. That would be where federal courts decline to intervene in elections in the weeks or months leading up to an election. That has been adopted by various cases or in different forms by courts across the country, including the New Hampshire Supreme Court. Essentially, that principle is that courts should not be intervening in the final months, weeks, or days before an election in a way that would sow confusion or create chaos in the actual administration of elections. Courts' understanding of a remedy can inflict great damage, or the changing of law, the changing of status, the changing of practice and procedure can inflict great damage on the exercise of democracy in the form of having our citizens vote. That applies months out from an election, weeks out from an election, earlier days before an election. The plaintiff is seeking to prohibit jurisdictions from utilizing devices to count ballots that have been used for decades. This court should not intervene and inflict that harm on New Hampshire's elections. The plaintiff has not met the legal burdens that he bears to address or for a preliminary injunction to be granted. And beyond not meeting those legal burdens, the principle of judicial non-intervention is essential in this circumstance. The changing of the procedure from using a ballot counting device to hand counting, the plaintiff asserts there is no harm there, that it is not difficult and that it's routine. Going back to the mention of more than 300,000 votes in a primary election in 2020, the time and the resources, the volunteer effort that would take to count those votes in the 75% of ballots cast that instead of going to a ballot counting device would have to be hand counted, would sow chaos in our elections. Election officials have not been able to, they are not structured, not been able to recruit the personnel required to extend the public meeting from hours past when the polls close to through the night or into the next day or subsequent days in order to hand count those ballots. Because not only would we be talking about hundreds of thousands of ballots, but each ballot may contain a dozen or more races, some with additional.
Maybe I just read his motion, but he specifically said it would be about 500 ballots in the town of Auburn. I read his motion as just specifically applying to the ballots in Auburn, based on the fact that he was saying there'd be no harm to the town because it's 500 votes, or at least that's what it was 2 years ago, or in prior elections, or whatever, it was a very small number.
And Your Honor, on information received, I believe that number is much too low. I believe there may be further testimony as to that and the impact on the town.
Okay.
But that is the ultimate objective of prohibiting the use of ballot counting devices here would disrupt election operations, would disrupt the ability of election officials in the final days before an election to administer an orderly election. Because of that, Your Honor, the state is asking you to deny the plaintiff's motion for a preliminary injunction. It is not proper, it has not met the legal thresholds. Factually, misstates the circumstances, misunderstands the law. It's not appropriate at this late stage to make this change with an extraordinary measure. It's not appropriate in the circumstances. Thank you, Your Honor.
Very good.
Thank you, Your Honor. So I represent the town of Auburn and the town of Auburn's interim town administrator, Mr. Daniel Goonan, who's here with me today, as well as the chair of the Board of Selectmen, who has been named as additional defendant in this case. I just want to point out a couple of facts here. By offer of proof, there's going to almost certainly be far more than 500 ballots cast on Tuesday. The number 500 was taken from a March local election. In the past 2 September primaries, there's been closer to 1,500, 3 times as many, and that has been in cases where there were particularly competitive primaries, unlike this year when the primaries are particularly competitive. And so we would expect at least the 1,500 ballots that we have seen in 2018 and 2020. I think it's also important for the court to understand that we're talking about 1,500 people voting on 26 races, which means that if you're going to hand count, you're looking at hand counting over 20,000 votes. This is not an easy effort. This isn't something that can be done in an hour or 2 hours or 3 hours. This would take a substantial amount of time, a substantial amount of effort, and is not prepared for. Particularly the case because some of these votes involve voting for the top 3 out of 4 candidates. Those types of elections are particularly time consuming in order to count by hand, which is why the town of Auburn does utilize a ballot counting machine. Now, while the town of Auburn does utilize a ballot counting machine, it had been determined prior to this case being filed that there would be a hand count box. So for the town of Auburn at least, there is going to be a box in which anybody who wants to have their ballot hand counted, including the plaintiff, Mr. Richard, doesn't need to put his ballot into the machine. And if Mr. Richard and 5, 10 other people decide they want to put it into the hand count box, the town of Auburn will be hand counting those in the hand count box. Final point I just wanted to make is that Auburn's machines have been tested, they have been calibrated. The town clerk, Kathy Silva, was present during the calibration and the testing, and that happened just a couple weeks ago this past August.
All right, Mr. Richard, any rebuttal?
Yes, sir, thank you. To cross on the last attorney, I apologize.
Attorney Tierney.
Tierney.
Sorry, I have all the names written down here.
By what standard was this testing, and this is part of my complaint, there are no standards in place or certification. Now, my expert witness didn't testify, but I can tell you, and the reason I had the photographs entered into exhibits is that they were initially UL certified when they were manufactured for safety. That's gone. As soon as they opened the box and started tampering with those devices, and they've never since updated their certification. So when he says they're testing and certifying and doing these various things, there are no standards. And who wrote the standards? If what exists was written by an unelected body, the ballot law commission cannot make law. But in this case, the legislature did grant 656:42, then it has the power to do that. Unfortunately, that's a whole nother subject, but the point is that there are no standards. I wanna back up a second, and the Attorney General's office talked about that there won't be a problem with hand counting versus machine counting, and that being an option. Sir, I was denied the right to vote. I went to my town on my primary day and went to my supervisor of the checklist, gave him my ID, said, I'd like my ballot, please. He's handed my ballot, and then asked where I can deposit in the hand count box. I was told that wouldn't be an option, that if you wanted to vote, there was one way to do it, and you use the electronic machine over there. I voiced my protest. I went to the moderator, filed my protest with him, and then followed up with the attorney here, and who was very helpful and said, look, we were following directions from the Attorney General's office. They've instructed, and that's part of the exhibit, I think, D in my filing. They instructed the towns, ignore the Constitution and follow the statute. That's what they instructed them to do. That's what they've instructed them to do. Ignore Mr. Richard and ignore his concerns until the court tells you otherwise. So here's another problem that we haven't talked about with machines. Violation of the Equal Protection Clause of the 14th Amendment. By allowing some towns the discretion to decide whether they want to adopt a device not approved by an amendment, and I'll get to that in a second. And then allowing some towns to do it, others not to. That's not equal application of the law throughout the state. The state legislature makes law. Why didn't the legislature say, hey, we're going to use electronic devices? Because see, I don't oppose machines. Matter of fact, what I'm opposed to is violating the procedural due process to achieve that outcome. Let me give you an excellent example. Absentee voting comes to us in 1942. This is part of my case. 1942, prior to that, there was no exceptions for absentee voting. How did that come to be? By an amendment. They proposed a yes or no question in 1942. The people said yes. From that period on, we had absentee voting. Same thing in 1957 with for the main election. 57 for the primaries. Rinse and repeat, same situation. The state proposed an amendment, the voters said yes, and now we have absentee voting. Okay? So I would say, I'm not against the machine. What I'm saying is that if you're going to change, and by the way, the state said that I was claiming that I misinterpreted Part 2, Article 32. I didn't misinterpret Part 2, Article 32. We have 200 years of usage and custom. Prior to 1979, there was no electronic device. Everyone counted by hand. That's what we had. So the fact of the matter is, the statute did make that change. Is the statute constitutional? That's what I argued in my pleading. State, by the way, has opened the door to my expert witness because he was citing the testimony from that report. And I would ask that if he's opened the door, then my expert be allowed to testify. To continue from there.
Your Honor, I object to that. Your Honor, I took the expert report under notice, so that you read it. I would read it again. Referring to content there, that is absolutely fair content here, but there's no opening the door for testimony. Nothing about anything that I said changes Your Honor's determination as to consideration of expert testimony and also the consideration of the court review of the record.
All right, I'm going to stand on my prior order where I'm going to take a look at it and read it and understand it. And I've read codes before, so.
Daniel,
I'm almost done.
can you ask for a minute?
You want to, yeah, leave.
We're done with the evidence portion. We're just an argument. You want to take 2 seconds to talk to him? Go ahead. Give him the opportunity.
okay, where's the evidence for no injury? Staff is not providing any evidence that they're injured by doing this by hand, that they're somehow going to be injured. Again, what is the de facto if we have a challenge to vote in hand count? So, they can get producing evidence. Using,
While we're
getting
there, let me ask you a question. Are you, it was unclear to the state, I thought it was clear to me, that you're just asking me to enforce an injunction against the town, not statewide.
well,
Because you did serve the Secretary of State and the Governor.
I did, Your Honor, because it all originates from that office, it all originates from the
My
legislature.
question is, who do you want me to prevent the voting machines to be used next Tuesday?
The town and the state,
Okay, so everybody.
everybody.
Thank you.
Getting away with it since 1979 should not, just because you've been getting away with it doesn't, I don't think that flies well in this courtroom when people try that argument. The Ballot Law Commission can't make law. This entire use of this device revolves around an entity that cannot make law. 656 statute, 656:42 has assigned those duties to the Ballot Law Commission. So that's what the towns are applying to here. They're not applying to the legislature, they're not applying to a body authorized to grant them the use of a device. Who is the Ballot Law Commission to say, we're going to ignore the previous usage and custom for the last 200 years, and we're going to adopt these new devices, and the whole thing is shady. Like I said, it began as a temporary use authorization, and they did nothing about it, especially after they had adequate notice back in February to start dealing with these issues and preparing for the upcoming elections, because they knew the upcoming elections were coming. And on that point, the Attorney General's office is concerned enough that it is now hired, I don't know if they're hired or just people have volunteered. Other attorneys are going to sit in the town of Wyndham, Bedford, and Laconia. Why? Because there were serious anomalies in the county and the way the vote, the election was done in total. So if there isn't a problem, they're clearly concerned about it. And so what did they do about it? They didn't do anything legally as far as changing the law or changing the statutes. And again, putting any standards in place. Certified by oh, evidence, but I want to refute what the AG just said, and that's what the sidebar was. One additional piece of evidence, if the court would allow me to enter into evidence. This is the ballots and the hand count from the Wyndham event showing overvotes and discrepancies in the system and how it works. And so these are copies of the tapes and the outcomes from Wyndham. Listen, Your Honor.
Sure, but I thought your preliminary request was based on work life safety issues.
It was.
That's
I'm
more
just
geared
refuting.
towards the merits of whether or not these are reliable machines in your
And so having said
Unless I'm
that,
misunderstanding your request for preliminaries,
yes,
a bit focused on that.
yes. And that's really the whole point of today's hearing is to, again, with all the attention focused on our elections, what's most important, I think, to everyone in this room, there cannot be a question as to the integrity of this coming vote. Because there's no way to start the primary season to continue the chaos that we've had for the last 2 years. Whether you agree or disagree with the outcome of the last election, what is irrefutable is public confidence. That's why there's a commission. Public confidence nationwide is now in doubt, and we've got to make sure, and that's why I think that the court should issue this injunction. Hand count, no one gets hurt, we preserve the integrity of the primary while we set another hearing at another time to work out whether they should be abolished completely. But that's what I'm asking you to do today.
We've given me enough to think about. Brief response?
Very brief, your.
Normally let him go last.
Excuse me?
Brief, because I normally let him go last.
Just, identifying the plaintiff, I don't think understands the operation of administrative law, Your Honor. He keeps on citing to the Ballot Law Commission and how they're unelected and establishing protocol CFRs, those are federal road regulation, those are exactly the same circumstance. He finds authority in the federal version that he agrees with or thinks applies here, but doesn't in the operation of New Hampshire administrative law. And then he made a reference to poll inspectors and election monitors. Your Honor, those
Those have been going on for decades.
yes,
They've had the
both of those
election,
programs there.
election department
It's,
going on forever.
it would be a misrepresentation to say that those are based on, anything unique, about the, ballot counting devices, operation or safety of the ballot counting devices. Those are the operation and administration of elections in those three different jurisdictions.
Okay.
Thank you, Your Honor.
I will be very, very brief.
Did they teach you to say that in law school?
Yes. Regardless.
You didn't take my class then.
Regardless of what may have happened in past elections, at this election coming up this Tuesday, the town of Auburn, where Mr. Richards wants to vote, will have a handicap box.
Mr. Richards, my practice is always to give the person with the
Thank
lead
you.
last up. I'm like the home team in baseball, so.
I'll just close out with this since you touched on the ballot law commission. Your Honor, 656-40, 656-41, 656-42. Those are the three statutes that all govern and control the use of this electronic device. But in the end, what's ended up happening is the legislature has delegated powers of all three branches of government to that body. It now has a judicial power. So 656:40 allows them to make law because they're allowing the towns are applying to this commission as to whether they should use a machine. The next thing is 656:41 is the police power. They granted the ballot law commission police power because who's the one examining these machines? A bunch of people who've been nominated, most of them are attorneys with no background in electronics. How can they be examining these devices to see if they're even suitable to be used for elections? 656:42, same thing. There is the power to make law. That gives the ballot law commission to make their rules and enforce them as law. And then finally, in 1982, they gave them judicial power. They now possess powers of all three branches of government. And this is a big problem. And so I'll close with that, so thank you.
Thank you very much. All right, I'm gonna, take this matter under advisement. I will, I'll probably issue an order within 24 hours. So you give me a busy day tomorrow, to kind of think through and sit through all this stuff, do some research. Is there anything else, that folks would like to submit? If you're going to, submit it by, tomorrow morning at 9 a.m., because that's when I'll probably start, drafting my thoughts on paper, okay?
Thank you.
All right, thank you all. All right.
So we just finished watching part 2 of the two New Hampshire election lawsuits that filed by New Hampshire citizen Daniel Richards to ban voting machines in the state of New Hampshire. That occurred today on Friday, September 9th, 2022. It started from 1 p.m. and it ended at 3:30 in the afternoon. Thanks for watching, everyone. Joe Kelly from Little Fire Media reporting live in Brentwood, New Hampshire. Signing out.
Very much familiar with what happens when you modify or do it on the place. You no longer do it on the place.
Thank you very much.
And every house fire would have to have a modified license to call your insurance company.
Right, I'm actually.
Signing out.